Good afternoon to all of you. It's great to be back with you. It's July 25th. We are right in the middle of summer and we have a terrific program for you and I will walk you through it. So if Kathy, you'd please flip to the agenda. Thank you. I'll let everybody know what's ahead. So I'll spend a few minutes with you and then Kate Hajar, who sits in the New York City office, actually our offices share walls. We will hear from Kate about hate crime reporting and new standards affecting college campuses. New is a relative term because some of what colleges are already doing is certainly valid, but Kate will get into those details for all of you, particularly for institutions of higher ed who are tuning in today. And then next we'll have Ariana DeWitz, who's a summer associate with us, who's going to be presenting along with Mario. Both Mario and Ariana will be covering Microsoft and FTC COPPA violation issues that make for both interesting news and interesting implications. It's important to note that Mario is overseeing Ariana today. And Mario is a regular presenter on our programming and certainly a familiar face to all of you. After that, Sam Burgess, a partner out of our Syracuse office and someone with whom I work closely and regularly on healthcare matters, is going to walk us through a business planning checklist of sorts. Sam thought it would be useful for all of you to think about governing documents, succession planning issues, and just to hear from someone who does this work a lot. And there's some do's and don'ts that might not be on your mind, but perhaps should be. And then Greendale Valley is with us from Florida. Of course, we have outposts, including in Naples. And what we're going to be hearing about are corporate structure considerations. So with that, let me turn to Kate, whom I'll introduce. I look forward to letting you know a little bit about Kate, who herself was with Bond as someone who did training and then decided to come on back and as a senior counsel, like I am, after a stint as a as a GC, excuse me, within a university in New York City. And what Kate will be talking about is hate crime reporting, as I indicated, and in particular, what has happened at the New York State legislative level and what that means for all of those who are affected by it and what it doesn't mean, because there are some misconceptions, but some actual differences that are important to pay heed to. Kate, we're delighted to both have you back with Bond and to have you on the program for the first time. Welcome.
Thank you, Gabe, very much for the invitation and for the work that you do hosting this program. So we have some brief updates to share with the group regarding the New York State education law, which will be applicable to those who are watching at colleges and universities. This month, just a few weeks ago on July 11th, the governor announced changes to the New York State, again, education law related to hate crime reporting. And these changes will go into effect in a couple of months, actually on October 9th of this year. And the changes appear, for those who are keeping track, in section 64, 31, 33, 34, and 36 of the state education law. The changes were announced within the larger context of $51 million in grant money designated by the state for projects aimed to strengthen safety and security measures at nonprofit, community-based organizations that are at risk for hate crimes or attacks based on their ideology or mission. So these changes to the statute fit within a broader context, the state's desire to reaffirm its commitment to combating hate crimes. For a little bit more background, the New York police departments, various police departments, sheriff departments across the state reported that there were 947 hate crimes in 2022, which is the most reported in the past 5 years and is a 20% increase from 2021. Some of these statistics do include several anti-Semitic incidents on college campuses and violent hate crimes elsewhere in New York. So briefly, what are the changes to the New York State education law that we're looking at? The first tells colleges that they must have their advisory committees on campus security review current policies and procedures that cover the education of the campus community about bias-related and hate crimes. Bias-related and hate crimes being two separate definitions of offenses. These advisory committees are also supposed to look at the college's existing procedures for how to report hate crimes and the available measures that institutions are able to provide to assist victims during hate crime investigations. Some of these measures for assistance would include things like counseling. The second significant change that we're seeing is that colleges are going to likely have to update how they disseminate information about hate crime statistics to the college community. Specifically, colleges must now indicate on their website how to access annual crime statistics that occur on campus. They must include a link to the U.S. Department of Education's website related to hate crimes, and significantly now, report and post instance of hate crime offenses as a separate, clearly designated category on the college website. Whereas in the past, colleges may have included this information within the annual Clery security report, this new language of the statute indicates that hate crime data has to sit distinctly somewhere on the college website. Students must be informed of these statistics, as well as the college's policies and procedures to address hate crime incidents during the college's onboarding process. And I know that many colleges and universities are already doing this in some fashion, but the changes we're seeing in this, in these additions explicitly point out this requirement to disseminate hate crime statistics in the manner I just described. Colleges must also adopt and implement a plan that provides for the investigation of hate crimes on campus in the same way that colleges are required in the same section of this statute actually to investigate violent felony offenses. So the plans must now include, for hate crimes, a written agreement with appropriate local law enforcement agencies, providing for the prompt investigation of such crimes, and a requirement that the institution notify appropriate law enforcement as soon as possible, but in no case more than 24 hours after a report of a hate crime. Colleges are already required to have such agreements in place with regard to violent felonies, as I just stated, and for missing students. But here, hate crimes, again, has specifically been added as a category of offense carrying these same requirements. And colleges are also required in this statute to inform incoming students about hate crime prevention measures, as, for example, colleges already do for sexual assault, domestic and dating violence, and stalking. I'll note that hate crime, for the purpose of this statute, for the purpose of these sections of the state education law, carries the same definition as hate crime is defined in the New York Penal Code. So, brief takeaway from these changes: colleges and universities, I trust, are already doing probably many of these things in some fashion. But this is a good time to take a look at your policies, at your websites, your reporting procedures, your investigation procedures, meet with your campus security officials, look at your training materials to make sure that you're meeting these requirements that are spelled out in these sections of the statute, and make any necessary adjustments ahead of the October 9th deadline. Of course, if you have any questions about these changes or about the education law as it relates to campus safety, crime reporting, security, we'd be pleased to discuss those questions with you at your convenience. And thank you, Gabe, very much.
Very much our pleasure to have you on the program, Kate. Thank you so much. And as Kate noted, this is a good time to check on your policies, check on your procedures to make sure that with the space between now and October that you are compliant. And if you have questions about whether you are, please reach out to the bond attorney with whom you work most regularly. we're here to help. And with that, let me turn to our next presenter, please, or presenters, I should say. We'll be hearing from our Buffalo office, and in particular, Mario, who is back with us and regularly has presented on the program concerning cybersecurity and data privacy issues. And with Mario, we'll be also hearing, as I noted, from Ariana DeWitz. Ariana is a summer law clerk that Mario has both supervised throughout the summer and is doing so in this instance. And they'll be telling us a bit about what we should take away from the Federal Trade Commission and Microsoft and these COPPA violations, what it all means and why we should be both concerned and attentive. And so with that, I want to turn the floor over to my two colleagues in Buffalo. And thank you so much for taking the time to make this presentation to the audience.
Thank you, Gabe. It's good to be back, and thank you everybody for spending your lunch hour with us. As Gabe mentioned, I'll be handing the reins over to Ariana, who did a lot of the work and research on this and has done an excellent job this summer supporting our team, including a large project where she tracked every state privacy, consumer privacy law, what the requirements were, what we needed to include in public disclosures, and has been a tremendous asset to us. So I will be back at the end of the presentation to field any questions. I can also take questions offline if you have things for a longer discussion. I will turn it over to Ariana, who will begin our presentation.
Thank you, Mario. I'm here to talk about Microsoft and the recent settlement, the $20 million settlement that they did with the FTC. Can we turn to the next slide, please? So what is Microsoft Xbox? Microsoft is a gaming console released in 2001 that promotes online. It's an online gaming application. Next slide, please. So in 1990, I'm going to give a background on COPPA. So COPPA is a Children's Online Privacy Protection Act that was enacted by Congress in 1998. And in 2000, the FTC promulgated and imposed several requirements for online services to protect children under 13. Next slide, please. Microsoft is subject to the COPPA rule because a lot of their advertisements and promotions are directed to kids, and the game is popular amongst children. Children play Xbox. Next slide, please.
If I could just jump in really quick, if you could go back to the previous slide. These findings here are what the FTC is looking at when they're trying to make a determination as to whether a product or service is directed towards children. So it's always going to be a fact-based inquiry. In a previous enforcement action, they looked at another gaming website. They looked at their advertisements. They looked at their merchandise. So it's a factual-based inquiry. So it's a good thing to keep in mind for your business. If you're developing marketing materials, if you're developing ad campaigns, if you don't intend to market towards children, you need to be very conscious about what types of content that you include, because the FTC is going to take each case separately and do a factual deep dive to see whether your materials, whether your products or services could be perceived to be marketed towards kids. So that's just something to keep in mind there. Back to you.
So the FTC's allegations were that Microsoft failed to provide notice and obtain verifiable parental consent when making accounts. And then also the Microsoft retained personal information for longer than reasonably necessary, according to 16 CFR section 312.5. Next slide, please. So to create a Microsoft account, the user must provide personal information such as their name, email address, and date of birth. And prior to 2021, users were prompted to enter their phone number before parental consent was obtained. And it is important to note that although this has been rectified, the FTC is still looking into violations that have been cured. Also, the notice requirement for Microsoft was insufficient, they would have the parent confirm the account, and then they would provide notice. And also, the notice did not contain information about how the child's information was used. Next slide, please. So from 2015 to at least 2020, Microsoft retained the children's personal information for longer than necessary. And it wasn't just children, although this is specifically geared towards children. Approximately 10 million individuals had their information retained for longer than necessary. And it's a COPPA mandate to delete information. Next slide, please. So the proposed order that the FTC wants to implement along with the $20 million settlement is to have parental consent, providing notice. They must retroactively inform every adult account about the protections that will be applied to children, whether or not there is a child account attached to it. And then Microsoft must maintain a system to delete information within 2 weeks from collection if parental consent has not been obtained. Additionally, Microsoft would be mandated to report their compliance back to the FTC. Next slide, please. I'm going to turn it back over to Mario to give the takeaways. Thank you.
Thanks, Ariana. So looking at this enforcement action along with other previous FTC enforcement actions, we're definitely seeing an uptick in the FTC's attention towards children's privacy. So we saw Epic, which is one of the largest media production and publication companies, were fined. We saw Amazon fined because of their use of Alexa and their inability to differentiate the difference between children's input of data and adults. And so, and we're seeing these really attention-grabbing settlement amounts, $20–30 million. And this all leads to pointing towards the FTC is really starting to focus in on children's privacy. At the end of last year, the FTC issued an advance notice of proposed rulemaking where they flagged children's privacy in the context of collecting data online from products and services as one of their top priorities for the next year for rulemaking, or for even the creation of new agencies that will focus directly on this. So what does this mean for your business? Obviously, we're seeing right now a lot of larger businesses, like the Microsofts, the Amazons, targeted as a way to signal the importance, but it's only a matter of time before the FTC is going to start routinely looking into other websites, maybe smaller companies, and seeing how they interact with children online. So a couple things to keep in mind is the easiest way to prevent any regulatory attention in this area when it comes to the collection of children's data is always just provide disclosures, provide notification of your collection practices before you collect information. A lot of these cases, it wasn't that the company didn't provide information about what was going to be used or how the information was going to be used, but it was, as Ariana mentioned, it was the timing. It came after the fact, or it was buried in a privacy policy where you couldn't find it. That's not sufficient. At the point of collection, so most websites will have a newsletter sign up or a mailing list or contact form. All of those forms and sign up sheets, they collect personal information. And if your business is not geared towards children, or you do not want children interacting with the website, you need to say that up front. That's the first line of defense that you can use. It's cost effective. It doesn't require much. And it's a way to signal and it's a data point to point to if litigation arises that, look, our users were on notice that this wasn't for us. If your website is geared towards children, or if you do want children to use the website, then there are other things that you need to worry about, COPPA being one of them, obtaining verifiable consent from parents before account creation, not retroactively. We see a lot of services, once the kid reports that they're under 13, they'll let them finish the account creation process and then they'll contact the parents. That's not going to work. There has to be verifiable consent, and there's a reasonable requirement for investigating whether parental consent is viable. That's a little bit more in the weeds, but making sure you get consent right off the gate and making sure you provide notice right out of the gate are going to be your two biggest shields towards any regulatory attention. And then finally, we've seen companies who are the main focus of these FTC investigations, they dig deeper into the information retention practices too. So that's COPPA requires information to be deleted after the original use, but that's also larger bodies of law too, like the GDPR, CCPA, other state laws. They're really focusing on this minimization. And if you combine that with the improper collection of children's information, that's going to be an issue. So yes, there are significant fines attached to violations of COPPA, but the good news is it isn't difficult to set up a system on your website where you can comply and easily protect your business, your organization from FTC attention, from lawsuits and the like. So Gabe, with that, I will send it back to you.
Thank you very much, Mario, as well, Ariana. Terrific presentation. And Mario, as you point out, thinking upstream about COPPA and the way it affects your businesses is critical. Whether you're a large one that does work with bond or a smaller one that wants to plan ahead, we have a team here that focuses on data privacy and cybersecurity, and we're here to help. And so thank you for that context, you both, and we'll move on now to our next presenter. And that's Sam Burgess. Sam is a member in our Syracuse office. Sam, as I noted, and I have worked together. We both focus on healthcare and various aspects of our practices. Sam does so a bit more so than I, as it were, from transactional perspectives. And with that comes with background and experience that we thought would be useful for all of you concerning business planning. And so we're really glad to have Sam on the program to share some do's and don'ts, some tips that we think will be quite helpful to all of you thinking about various aspects of your businesses. So with that, Sam, looking forward to hearing what you have to share. Thank you so much for being on the program.
Thanks, Gabe. Like Gabe said, my name's Sam Burgess. I'm in Syracuse. I'm in the business department, business and transactions. With that, I handle all sorts of businesses, large, small, different industries, professional industries, healthcare, design professions, accounting, things of that nature. And I thought it would just make sense to kind of have a practical discussion about, your business organization, your corporate documents, your corporate records, and how to make sure you're not only planning for the present, but you're also planning for the future. So with that, I'm just going to take some quick time to just kind of go over what a few points I think might be necessary to kind of bring back up to you. So I'm going to kind of start it in the corporation and limited liability company aspect, the two main ones that we usually deal with, but the same things apply for, partnerships and any other entity that you may have. So as many of you probably know, when you form an entity, you start with either the certificate of incorporation or the articles of organization, depending on the type of entity. And then you're supposed to get into the other governing documents, the bylaws, operating agreement. And these documents are the ones that are going to outline management of the company, how decisions are made, what restrictions you may have on each owner, how decisions are made, whether it's, by the manager, by the president, by a board. Is there a majority? Is there a supermajority? And a lot of times what happens is, especially for the smaller businesses, the family businesses, or even businesses that have been around for a while, they form their entity to get started. They don't want to waste much time to go through all of the steps to create a robust operating agreement or bylaws and shareholders agreement. And they don't have the proper provisions that they need when an issue may arise. So I just want to kind of talk about some of those provisions with you here briefly, and make sure that you're going back and looking at your documents to make sure that you have everything that you need. So with that kind of comes, it's going to be couched in a succession planning considerations context, but there's also other provisions in these documents that go to the management, that go to, when you can make a decision and when you can't make a decision, when meetings have to be had. But a lot of it comes down to what people want to know is, how can I get out of the company how can I get my partner out of the company? How much am I going to get paid? Things of that nature. So the main one is, the first concept here is really just what's the transferability? What are the buy sell provisions that you may have in your agreements? These can be wide ranging. You can have a very, very strict restriction that, there's no transfers unless it's agreed to by all the other owners or by a certain percentage of the owners. Or you can have restrictions are permitted or transfers are permitted if you give a right of first refusal to the other owners, allowing them to purchase your ownership at the same terms that you'd give it to a third party. So those are all different ways that you can transfer your interest, or that your partners could transfer their interest. You want to make sure that you're not getting stuck with a partner that you don't want. So with the transferability, with the buy sell provisions, you want to spell out each instance of when you as the remaining owner or as the departing owner would like to either get out or stay in, such as death, disability, retirement. Just because you want to voluntarily get out of the company, you don't get along, termination of employment. So those are all different provisions that you should have in your agreements, and they all take on different forms. Whether it's, upon death, there's a requirement that the company buys the interest, or the company has an option to buy your ownership. Those are different things that you're going to want to take into consideration and plan for if you haven't already. And with these, you also got to look at how you're going to determine a value and how you're going to pay for it. If the company is the one that has to make payments, where's the company going to get money from? Do they have cash on hand to pay it? Do they have a line of credit or other financing options? Are you going to require that the seller, that the departing owner holds a promissory note? Are you going to pay a percent down? Those are all things that we want to take into consideration now before it comes time to have the discussion. Because when someone is leaving or something happens that you want someone to leave, or you disagreements are in play, it's going to be too late to make these decisions because everyone's going to be out for themselves at that point. You want these to be taken care of when everyone's on the same page at day one, to make sure you are all in agreement of, okay, this is how much I'll be comfortable paying, as well as this is how much I'd be comfortable getting paid. So those are just kind of the main focal points of transfer restrictions, succession planning. And with that, it's a little slight plug for ourselves, but also other professionals. You should have your team in place, your advisors, your accountant, your lawyer, financial investment advisor, of all in place. So everyone's on the same page of when you're trying to move along the continuum of your business, whether it's a family business going to the next generation, whether it's being sold to a third party, whether you're going to sell to private equity, making sure everyone's on the same page and we're moving in concert with each other. So with that background, I just want to kind of touch on what are some pitfalls, mistakes that happen, and kind of some real life examples of that. So, lack of updated governing documents and records. Here, basically what we're talking about is either you don't have the operating agreement in place, you don't have a shareholders or bylaws in place, or they're extremely dated and they don't take into account your actual business to date. Or not maintaining records. So, yes, you may have new owners in since the inception of the business, but you can't really find the documents of when that person became an owner, how they bought in, anything like that. That's going to impact your ability when you go to sell and make the next transfer of, what representations you can make. Can you really say that this is the ownership? Do you have the documentation to protect yourself? Then, failure to adequately address the future. This is kind of what I discussed before about having succession plan in place, having those transfer restrictions, having the buy sell provisions. without those, you're not going to be ready to either go from a split, a breakup, or for retirement, or an unplanned death. Things of that nature, you're not going to be ready for if you haven't planned for them in your documents. And that goes right to the next point. Many entities that I deal with, I find to be they're reactive instead of proactive. Someone dies, they want you to, okay, what do we do now? As opposed to, we've already contemplated in the agreement. We know that, you just give notice, you redeem them. Here's how you value the interest, and go from there. Also, by being proactive, when you get along, you can plan for any disputes that you might have in the future. So also, making sure you're not stuck in the business with either people you don't want or no clear exit strategy. If you don't have the proper documentation, you run the risk of being stuck in the business yourself without being able to cash out. The potential that your current partners, the other owners, can freely transfer to third parties, freely transfer to their spouse, their siblings, their kids, people that you don't know or haven't run a business with, that you don't want to be working with for the future, but you have no other way around it. So with that, I just kind of want to give you, I dealt with some instances recently where some entities were formed and, no governing documents other than the articles were prepared. There's no operating agreements, and one member wants to retire. Well, we don't have a plan for that. We haven't discussed that. It hasn't been addressed in the documents. So therefore, right from the start, they don't have governing documents or records of how they're going to deal with it. They haven't discussed what they're going to do in the future because, whether the conversation was too difficult or they don't want to, hey, there's no need to it. We are all getting along. We'll just agree when the time comes. So we haven't addressed the future. So now we're trying to be reactive, and people's interests are not aligned anymore. Obviously the departing owner wants to get the most for their interests, and the company / the other owners don't want to pay them that much, but we don't have a mechanism in place. So what end result being is either one party doesn't get fully what they want, you get stuck together in your business, working together for longer than you wanted, and you still don't have that way to exit. You're stuck in the business just because you didn't spend the time on it from the get-go. So with that, what I kind of just want to bring around here is, the governing documents should be living agreements. These aren't documents that you form when the entity is formed, and through an ownership transition, you might just amend it and add the new owner in there. You should be constantly looking at these documents to plan for how business is operated today. Make sure it adequately defines how decisions are made. It adequately takes into account how you want the business to be valued, how you want one person to get bought out. You should always be looking at these on a regular basis. Obviously when there's change in circumstances, with more new owners, yes, but even on the regular without it, that's just what I want to leave you with, is just go back and look at your governing documents, make sure they're in place of what you want now, and reach out to the attorney you work with at bond, reach out to me, and we can look through those and talk about them together to make sure we're all on the same page and we're ready to proceed for the future. And with that, I'll turn it back to Gabe to continue going. Thanks, Gabe.
Thank you, Sam. And to your point, it's a good time to take a look at your governing documents, and if there are tweaks to make, reach out to the bond attorney you trust in order to evaluate what can be done and what can be improved. The summer is a good time to dust things off and otherwise take a look. So we encourage all of you to do so. And Sam, we thank you for coming on the program to share that guidance. And so let's move now to our final presenter, who is with us from Naples, Florida. Raindell Valley joined bond recently and comes to us with both a JG and an LLM. He has expertise in taxation and focuses on estate planning needs, things like will drafting, trusts, and estates, but really prides himself in approaching these kinds of dynamics with creativity. And when Raindell heard about the program, Raindell was interested in presenting on it and thought that it would be a good time to talk about corporate structure, not exactly in the same way that Sam was addressing things a moment ago, but we thought these two presentations might neatly dovetail. And so what Raindell is going to look at is the federal tax perspective on corporate structuring. And we're glad that we have a representative from Florida with us today. As we know, we of course have Floridians tuning in as well. And we look forward to having you back on the program, Raindell, and glad that you can make this first appearance. Please go right ahead.
Thank you, Gabe. And happy to be here presenting from the burial ground of the East Coast, Florida, as I like to say. So starting with a brief overview of my topic, corporate structure considerations, a federal tax perspective. We're going to be discussing the form of business organizations under state law. So your options essentially when you're starting a business, the federal tax considerations and compliance requirements for said business organizations, and some non-tax considerations, which were mainly covered by Sam. Thank you, Sam, for adding more to my presentation without any of my effort. And an example of an entity structure to accomplish certain tax goals that would impede expansion or rate of return on certain investment dynamics that are involved in, say, the real estate area. So next slide, please. So we have different forms of business organizations here under state law. Generally, a sole proprietorship is a solely owned and operated business entity. There's no formal requirements or filings necessary for a sole proprietorship, similar to a partnership, as may be believed that you need to file some sort of partnership agreement with the Secretary of State, or no, that's incorrect. Partnerships operate by actions. They're juridically created by one's actions of sharing of profits in the business, similar to a sole proprietorship. Once you start a business and you are the only owner and operator of the business, that is it. You have a sole proprietorship. So unfortunately, sole proprietorship doesn't afford any liability protection. So you're kind of exposed to all of the expenses, creditors, claims of the business, as well as reporting of the income generated from the business. Then we have a corporation, which is a juridical entity. It's a legal fiction. It's a separate legal entity created under state law and respected for federal purposes, for federal tax laws. And we're all familiar with the corporate veil. The owners or the shareholders of the corporation are afforded liability against the claims against the entity itself. However, it's worth noting that the actors, the directors and the officers are still liable for their own torts, but there can be a workaround with an exculpation clause or perhaps an indemnity clause within the corporate documents. And I highlight here that there's a C Corp versus an S Corp. This is both sort of a state and a federal law distinction. A S corporation is essentially a flow-through corporation, which I will discuss in the next few slides what a flow-through is. And a C corporation is essentially a corporation taxed under subchapter C of the Internal Revenue Code, IRC, and an S corporation is taxed under subchapter S, generally, but also subject to some subchapter C rules. And then we have various forms of partnerships. The LP, the limited partnership, has limited partners and general partners. A limited partner is afforded liability protection against the claims of creditors to the extent, well, not in excess of their capital contribution. So whatever their capital contribution is still on the hook for any claims or creditors coming after the partnership. We have general partners, which manage the day-to-day operations of a partnership. And there's also limited partners, which are sort of a more passive investor capacity within the partnership. General partnership, it's just all general partners. So all managing partners of the partnership, and they all have unlimited liability to the partnership and the claims of creditors. We have in most states limited liability partnerships, which afford enhanced protections to the limited partners, including protection from vicarious liability for the actions of the other partners. So there's that additional benefit, and we have limited liability limited partnerships, which some states allow as well. And this will essentially give liability protections to the general partners of the partnership. Publicly traded partnerships, they are essentially partnerships with interest sold on a public securities market. For tax purposes, generally are treated the same as corporations, but there are certain rules and exceptions where they can be treated as a flow-through, as I'll explain in the next slide, as a flow-through entity. And a joint venture is essentially a short-term partnership. So these other partnerships are in contemplation of a long-term business endeavor. The joint venture is a shorter period, perhaps a gathering of 2 or more individuals to purchase or sell certain plots of land, for example. They don't have to necessarily be formed as a partnership or an LLC, but they can be, and they could just by operation of law, again, like partnerships, form, I guess, from a legal perspective, just by the actions of the partners or the members of the joint venture. And then we have the very famous entity, the limited liability company, which is sort of the most flexible and the best of both worlds, as a lot of people like to refer to it as. They give the members and the managing members limited liability for or liability protection for the creditors and claims against the entity itself, and have sort of the flexibility of partnerships in terms of its agreement and in terms of the tax options available to the limited liability company. Can I have the next slide, please? Right, so here's what I was sort of referring to in the last slide. We have subchapter C, which deals with associations and corporations per se, corporations under the code. It is taxed under a double tax regime, typically. So that means that the entity itself is subject to tax, and the operators or the owners are subject to tax. So there's currently, after the Tax Cuts and Jobs Act, a flat rate. It used to be a marginal rate, like individual rates for corporations, but now it's just a 21% flat rate, regardless of the character of the income or how much. So these are found under 11B. This is IRC section 11B, where you can find the flat rate. And operations and net operating income from the C Corp, the corporation, would be taxed at the flat 21%. Other distributions, so anything leaving corporate solution to the owners, would be taxed at the individual rates. Let's say if it's qualified dividends are treated similar to capital gains or long-term capital gains, and they're taxed at preferential rates. So there's some benefits there, but more often than not, when you're taking proceeds out of corporate solution, it's highly inefficient as opposed to other structures. So we have subchapter K, which deals with the pass-through tax regime. The pass-through tax regime essentially treats the entity as sort of a conduit of its owner. So whatever the entity makes in terms of net operating income is reported on the owner's return via a K1 on their 1040. There are filing requirements that if aren't met, or you fall astray of any compliance, they will generate penalties and interest on penalties for not filing your 1065 and so forth. But there's a benefit now, because since the corporate rate was changed to 21%, looking at it from a comparison, it would sort of discourage individuals from forming pass-through entities when the corporate rate is so low, and you can take advantage of return of capital and capital gain rates. So to the great equalizer from the Tax Cuts and Jobs Act is IRC code section 199 cap A, the qualified business income section, which gives, generally speaking, a 20% deduction on qualified business income. And qualified business income is anything from a qualified business or certain excluded special service trade or businesses within the code. To put you to sleep, you can find that in section 1202. Great read if you're having trouble sleeping at night, which basically excludes certain businesses from falling within the general 20% deduction benefit. I believe accounting, health, and law are per se excluded. Generally, if you have a trader business that's not excluded, or if you're not in the trader business of being an employee, you can benefit from the 20%. It's a very complex and it's a very complex provision that cross-references other areas of the code, but it's a very big benefit to flow-through provisions and flow-through entities, excuse me. And there's flexibility within partnerships. So you can sort of configure your partnership agreement to make certain distributions of certain items, in some cases to certain partners. And it's a great negotiating tool to really get the most water out of your stone. You're squeezing water out of stone essentially for each individual. Of course, there's certain limitations in subchapter K, and it's a complex provision, a complex subchapter, and I would highly recommend consulting with your tax professional with any planned endeavor in that area. So we have also subchapter S. This one is less flexible. It's more geared towards simplicity. It allows corporations, state law corporations, to elect into a flow-through or a single level of tax regime. It's a very limited subchapter in the sense that there's certain requirements. There can only be one class of stock, for instance, so there's not a lot of flexibility. Again, it's very simple. And there's anti-abuse provisions within subchapter S to prevent individuals from avoiding double taxation from the corporate form just by switching from a C Corp over to switching from a C Corp over to an S Corp. There's specialized tax regimes, as you see listed here, but they're out of scope for our discussion today. And I just wanted to go to the next slide just to illustrate the differences in the tax rates from the C Corp and pass-through corporations. So as you can see, and just so you know, the NITT is the net investment, NIIT should say, sorry, it's the net investment income tax. So that's for passive income. It's an additional 3.8% on top of whatever rates you're paying at that level. So operating income, you can see the differences between the pass-through and the C corporations here. Next slide, please. And here we have the exit strategies or the results from the exit strategies when you want to sell your interest, and the taxes that are tied to the sale of a C Corp interest versus a partnership interest. What you see there as QSBB, that's a qualified small business stock. When you sell that, if you meet the requirements of the 5-year holding period, capitalization test, and the active trader business test, you can get 100% after 2010, 100% exclusion on all proceeds from the sale of that stock. So next slide, please. And we have the check the box election, which is sort of what allows the LLC to be the best of both worlds. By default, the LLC, if it's owned by just one person, one individual, it's a disregarded entity, so it's treated sort of like a sole proprietorship for federal tax purposes. You still are afforded the asset protection aspect of the LLC from the state law perspective, but jointly owned or 2 or more owners of an LLC will be a de facto partnership. You can elect out of that to be treated as an association or a corporation, because LLCs are generally eligible entities under the code. And the way to do that is with a form 8832. Again, consult your tax professional for this. Let's move on to the next. Okay, we have again, converting a C Corp to a pass-through entity. As I briefly mentioned this, you can do it from a C Corp to a partnership as an LLC, but that would be a liquidation. So that can trigger tax consequences at both levels, entity and owner. And the other way around would be tax-free under 351. Just for the purposes of time, I want to skip state tax considerations and non-tax considerations and jump over to the last slide, sort of just to show an example of what combining some of these structures together can achieve from an investment standpoint. So an UPREIT is an umbrella partnership real estate investment trust. Generally, when you have a real estate investment trust, you cannot incorporate it into an entity without realizing tax. It's a realization event. Generally, a disposition of property to a corporation would be a non-taxable event under IRC section 351, but a REIT, an incorporation into a REIT or an investment company is an exception to that. But there's a workaround around here where the pre-existing owners of a real estate partnership can invest their real estate into an operating LLC, and through an IPO, crowdfund essentially an expansion of their investment for more real estate. The IPO will generate cash, which the pre-existing owners can use to pay off debts in exchange for their options or non-economic voting interests, and the public shareholders receive a common shares. And at any moment, this can generate liquid funds to the pre-existing owners because they can convert their options into actual stock, which would trigger a taxable event. But the name of the game is deferral. Defer as long as possible, and you can defer any appreciation in the interest or assets as the pre-existing owners by structuring your investment in this manner. And I think I'm well beyond my time, so sorry for falling over, but thank you for listening.
Oh, well, we are delighted that you presented, Randall. Thank you so much for taking this time. And clearly, there's a lot in your presentation. For those of you looking for the slides, they'll be posted online. Look shortly in your inboxes for an emailed version of the presentations. And if you have specific questions for any of our presenters, their contact information is on the slide on your screen presently. I'll be back with you in 2 weeks' time. Before that, you'll be hosted by Kristen Smith. And in the meanwhile, I'm wishing you all a very pleasant end to July and looking forward to joining you in August. In the meanwhile, a terrific afternoon.